Now is the time for all to stand and fill the room with their intelligence. There are two very different questions: what the clause is and what the courts will say the clause is. The first issue is for the legal scholar and the second issue is for the courtroom practitioner. Our first order of business is to answer a question we previously asked. The question was whether the defense of an unreasonable delay called lackeys might be applicable. The answer here is yes. The United States Supreme Court, in a case called SCA versus First Quality Baby Products, held applying the defense of unreasonable delay when there is a statute of limitations in the law is beyond the judiciary's power. In so holding, the court stated that lackeys is a defense developed by courts as a gap filler when a law lacks an express statute of limitations, which is precisely the situation with the disqualification clause. It means the courts may resort to this type of doctrine precisely in a case where the defendant is prejudiced and members of the public are prejudiced because countervailing fundamental rights are at issue. The United States Supreme Court, in a case called Anderson versus United States, held that every voter in a federal election, whether he or she votes for a candidate with little chance of winning or for one with little chance of losing, has a fundamental right to a fair election. It is the kind of thing that may blindside everyone. There are several constitutional doctrines, usually called justiciability doctrines: mootness, ripeness, political question, standing, lackeys. Most, but not all, derive from Article 3's case or controversy requirement, and some from the common law. Some of these doctrines include room for these types of reindeer games.